Good afternoon, everyone. We have a very 30-minute tight session and an esteemed set of panelists. But welcome to the session that's discussing data protection, unraveling it, understanding the execution, and the hurdles that we are facing, right? So this is the journey that began with the Puttaswamy judgment many years ago, 2017, and we have all seen different versions of the bill. The Justice Sri Krishna report being tabled in the Parliament, being withdrawn from the Parliament, the Joint Parliamentary Committee report being tabled in the Parliament again, and finally, this year in August, we saw the bill passed. And now we're all waiting for the rules and trying to understand what are the different challenges and what are we anticipating in terms of executing this bill. So I want to welcome each of the panelists here and Mr. Pavan Duggal, who's joining us virtually as well. But I'm sure all of you know the panelists, and your program dossiers will have their introductions. So I'm going to go straight into the discussion in the interest of time. Can I ask Akshayy to start with a basic overview of the core principles and the framework that businesses have to keep in mind when they're thinking of executing and complying with this law?
Thank you, Gangesh. Good afternoon, everyone. So essentially, there are the 7 core underlying guidance principles which form the framework of the Digital Data Protection Act. Number 1, lawfulness, fairness, and transparency. So companies must process personal data for a lawful basis or a lawful purpose, and that lawful purpose needs to be met for each different processing activity. Companies need to process data in a fair manner, taking into account the interest of the individuals whose personal data is being processed, and transparency, that companies need to be transparent regarding the personal data that they collect, the various purposes for which they process their personal data, as well as the various third parties with whom that data is being shared. So that information needs to be provided to all the individuals. The second guiding principle is purpose limitation. So there's an obligation on companies to ensure that they process personal data only for the purpose for which it was collected in the first place. So you can't collect personal data for purpose A and then at a later point of time use that data for a different purpose altogether. Thirdly, data minimization. So companies have to ensure that the personal data which they are collecting and processing is limited to data which is necessary for them to provide their service. You cannot force individuals to provide data which is excessive and really may not be necessary for the purpose for which you are asking the data for. Fifthly, accuracy. There's an obligation on companies to ensure that whatever data they have in their database is kept accurate, correct, and consistent. Storage limitation. So today, companies cannot collect data and save it for perpetuity. You can only store data for a particular period of time. So once the purpose for which you had collected data in the first place, once the purpose has been served, then you will be required to delete the data from your database. And also, in fact, if you've shared that data with any third-party data processor, then it is your obligation to ensure that that third-party data processor also deletes the data from their database. The last 2 guiding principles are 1, integrity and confidentiality. There's an obligation on organizations to ensure that they implement technical and organizational measures as well as reasonable security safeguards to ensure that personal data is protected and there is no personal data breach. And lastly, accountability. So it is a data fiduciary, and a data fiduciary is the entity which determines the purpose and means of processing of personal data, the entity which determines why personal data needs to be collected and how that personal data needs to be processed is accountable under the law. So even if there's a violation, for example, by a third-party data processor, ultimately under the law, it's the data fiduciary who will be penalized for the violation. So these are the core principles that form the framework of the DPDP Act.
Right. Thank you so much, Akshayy. I think one of the things that we realize when we look at this law is how consent is king, right? And what I want to really understand, I want to bring Dr. Karnika Sethi here. Karnika, can you tell us your views on the consent and notice framework that we have under this version of the Act that was passed? Because we've seen how it has evolved with different versions, and what are your views on what we have as law right now?
Consent is very centric to the DPDP Act, as we all understand. And when we talk about consent, it is not something which is For example, silence of a particular person will not be a consent if there is a particular affirmative action which shows that yes, there is an agreement. For example, a checkbox being ticked by the user, that would be a consent because it has to be express, it has to be very unambiguous and very clear, and it's not something that one could only imply consent through conduct. So that's very important for us to understand the importance of consent in this act. So there has to be a very clear, unequivocal yes to the agreement, and in whichever way it would be, but very explicit. Only then there would be a consent which is considered as a deemed like a proper consent in the DPDP Act. And when we say consent now, age of consent, it's like 18 years and above. So a person has to be of that age. Otherwise, the consent would be invalid if it's a minor. In that case, there would be a parent or a lawful guardian who can give a consent if one is below 18 years of age. In case of disabled persons, again, there has to be a lawful representative who can give this consent. Now, definitely when we say notice, there has to be a notice given to take that consent, because the notice has to explain very clearly what are the kinds of information which is being asked from the data principal. For example, if it's personal information, your address, your date of birth, your health record, it could be anything. So this DPDP Act doesn't have separate categorization of what is the data being collected. So it doesn't have to be categorized into sensitive or non-sensitive. But yes, we must understand this is going to be only personal data, not non-personal data. So in that regard, the notice needs to say what information is being collected, how it is going to be used, for what purposes it's going to be used, and if there's a processing, then what kind of processing, how long it will be retained for, and the user rights. Explain the user that he has or she has rights, for example, to access that data which is given, to update it in the records, to ask for, even ask for a withdrawal of, give a withdrawal of consent, and ask them to stop processing the data. And so on and so forth. There are user rights. In case of grievance, they can actually approach a consent manager and write to the manager to ask for the query that they have, and that has to be responded to. So all those rights, they're explained in the notice. And it's also explained that if the user's consent is given for a particular thing, he can very well withdraw it. And if the query is not resolved by the consent manager, one can approach the DPP board, that is the Data Protection Board. So all those things have to be mentioned in the notice. And that's why whenever you see in the websites, when you're going on to websites to see there is a terms of use template, there is a privacy policy template. So those have to be very clearly read, understood, and an affirmative yes or a consent has to be given to that notice. And then only it will be considered as a proper notice under the DPDP law. However, there's one right, I just want to mention that. Consent may be not needed in certain legitimate uses. For example, there could be a disaster, a flood. Then the government is trying to help the users, so their data can be used for that purposes. There could be a medical emergency. There could be something which is jeopardizing the interest of the country. So the data which is there can be used. Now that data in the DPDP is not something which is already in the public domain. That is also important to be mentioned here, because any data which is used for personal or domestic purposes is out of the purview altogether. And even the data which is in the public domain is altogether out of the purview. However, such data which is collected and then that data is exempted from such taking of the consent in such cases which are, for example, to preserve the interest and sovereignty of the country, or where there is prevention of incitement to commit a particular offense, those kind of grave situations as well. So those are certain situations which do not require a consent in the DPDP. One can actually elaborate a lot, but I think in crux this is the what falls under consent and notice requirement.
Thank you, Karnika, for that. In fact, it sort of opens up this Pandora's box in my mind, not just in terms of what businesses need to do, but in terms of what users need to be aware of and understand so that they can really exercise their rights. But coming back to sort of the burden on businesses and data fiduciaries, as they are called, or processors under the Act, I want to bring in Dr. Pavan Duggal. Pavan, could you walk us through this, very commonly used phrase in data protection legislation, which is technical and organizational measures and reasonable security safeguards? I'm sure in your experience, you've seen this used a lot, and it's there previously in the IT rules as well. So would you like to walk us through a bit about what it could mean and offer some guidance on it?
Well, thanks. The crux of the matter is that this is the Digital Personal Data Protection Act, which is dealing with personal data protection. However, you cannot have personal data protection divorced from cybersecurity. But when I look at this particular law, there's not a single reference to cybersecurity. As a result, the legislators have said, let's not insert this particular clause where companies and all data processors and fiduciaries will be required to come up with appropriate technical and other measures so as to protect data. So I'm effectively reading that this particular provision is incorporating therein the provision for coming up with appropriate cybersecurity mechanisms so as to keep data safe. In any case, when I look at this particular law, this law is not a special law, and it is only in addition to other laws. So the primary legislation on information technology, being the Information Technology Act 2000, continues to be the superior legislation by virtue of Section 81 of the IT Act, which says that the provisions of the IT Act shall prevail over anything inconsistent therewith contained in any other law for the time being in force. Having said that, when I look at the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011, I find that the rules stipulate all intermediaries to implement and maintain reasonable security practices and procedures, and have stipulated an ISO 27001 as one example of reasonable security practices and procedures. The IT rules 2021 once again reiterate the need for intermediaries to go ahead and come up with the cybersecurity mechanisms and reasonable security practices and procedures. Now, the golden question right now, or the million-dollar question right now is, what will be these technical and other measures that the company would be required to take? That's something that we'll have to wait for the rules to elaborate. One thing could be that the rules will say, well, we already have stipulated an ISO 27001, so we would want you to comply ahead with all parameters of ISO 27001. I also expect them to come up with further additional parameters of due diligence vis-a-vis technical aspects of cybersecurity protection. But having said that, it's all wait and watch approach. I think things will all get clearer towards the end of January by the time when we have detailed rules. But I think the companies, whether it's all the three stakeholders in the ecosystem, whether it's the data principal, whether it's the data fiduciary, or whether it's the data processor, everybody has to tighten their belts, primarily because this obligation is going to be having an intrinsic connection on the way how the provisions of this act are going to pan up in the context of the specific obligations of these three important building blocks of the data economy and the data protection ecosystem. So let's wait and watch what happens. But yes, the more we stipulate for protection and preservation of cybersecurity, the more it's ultimately going to help us create a far more secure data economy ecosystem. The only problem is going to be that because you have not specifically come up with either a dedicated national law on cybersecurity, nor have you come up with dedicated mentioning of the term cybersecurity in the context of the Data Protection Act, the moot question that's going to be, can the rules supersede, or can they go much beyond the ambit of what the primary legislation is? That's, I think, a grey zone. The law is very, very clear. The rules cannot go ahead and overreach the ambit of the main law. But because the specific language that's been used, I think the government will have that arm's length approach and a flexibility to go ahead and stipulate more parameters for these technical aspects of data protection and cybersecurity. Thanks.
Right. Absolutely, Pavan. I agree with you. And in fact, so also anticipating sort of the shelved cybersecurity policy from many years ago, there have been different drafts being discussed, and also, the interaction between the DPDP and other laws. But I think Karnika had a short comment.
Just wanted to mention that the DPDP Act also seeks to omit Section 43A of the IT Act. Section 43 of the IT Act envisages or rather prescribes reasonable security practices to be adopted by body corporates. That is, when they take data, how they need to put in place technical measures, organizational measures, and the SPDI rules, which have been so far applicable, which also talk about the ISO 27001 as a standard, one of the deemed standards, which satisfies this criteria, will actually have to go. So there would be something new which will be prescribed when 43A goes. In my view, SPDI rules, which were called out under that, may also be changed or have a completely new regime altogether. We'll have to again wait and watch for this.
Right. Yeah, I think this interaction with other laws is something that we need to really pay attention to. But that also brings me to how this law interacts with other laws across the world. And I want to bring in Neha here, Neha Madan. Would you like to sort of walk us through a bit about how this law compares to the GDPR, which is often considered a gold standard, and what are the differences, what are the similarities, any challenges that you see?
Sure. I think GDPR has been the most talked about legislation world over, right, when it came in. And I think it has led to the formulation of data privacy policies, of various organizations having multi-jurisdictional businesses. And of course, many countries went on to the drawing board and revised their data privacy legislation when GDPR came about. Now, I think the one thing, and this is the practical thing that, we as lawyers face, that, somebody who is compliant with GDPR, they're coming and asking that how different is the Indian, law is, and are we compliant, not compliant, and do we need to do something extra? So I think while there's too many similarities, but there's some divergences as well. To just set the perspective, GDPR was more minute in detail. It addressed a lot of practical scenarios, but the Indian law for now has left many nuances, has left many things to interpretations. For example, what is covered under personal data, personal information. Just giving an example, we do not have different definitions of personal data. We do not have different categories. What is sensitive personal data? Unlike the SPDI, which did have two levels, two categories of information, which is personal information and then sensitive personal information. The new laws basically puts everything on the common bucket: personal information, personal data, and everything needs to be provided the same level of protection. GDPR did explicitly set out that user profiling. If any organization, any e-commerce platform, or anybody is profiling the user data, that is specifically covered in personal data. Now it is left to the interpretation that if I'm collecting any information of a user online, doing the profiling, do I have to even if it is not even if it is anonymized, do I have to cover it, not cover it? This is the practical implication what people are facing now. And of course we have to offer the same level of protection to all kinds of data, whatever classifies as personal information or data. Now the other I think divergence from GDPR has been what happens is data breach. GDPR clearly said that the organizations have to take the decision that did the breach in fact impact the rights of the users, or basis the volume of data, basis the kind of information they were dealing with was sensitive enough that you have to inform the breach about the breach. But Indian law for now, it says that every breach has to be informed. At least that's what the interpretation for now is, right? We don't have rules around it. And do you have to report every kind of breach? Now, third thing is the privacy notice. I think everybody thinks that the moment we have a privacy notice, a privacy policy on our website, we are basically compliant. But there's much more to it. But the Indian law has basically gone and said that you need to even only in case where the consent is the basis of you processing the information or the data, personal data, you have to give that notice, but not otherwise. Legitimate use, you need not have a privacy notice. So now organizations have gone back and asking, do we really need a privacy policy? Because it is covered in our contract. We have a legitimate use of the data. Do you still need to have data privacy policy on our websites? Or even formulated for that matter. Then, while GDPR did ask you that, even if you have a legitimate use, you have to inform the data subjects, what is the data principles under the Indian law, that, you need to inform them what data are you collecting, for what purpose you're collecting, how will you exercise the rights, etc., which is there in DPDPA as well. Now, another important divergence is the role of the data processors. Right? GDPR did, implicate or does implicate processors if they do not follow what is there in the GDPR. They're required to have reasonable security practices, in place. They have to follow the law. In India, there's no obligation on data processor. It is left to the data fiduciary to basically ensure the data processor is complying. So essentially, if a data processor breaches, it's not a breach of the law per se, but it is a breach of its contractual obligation towards the data controller or the data fiduciary, as we call in India. Now, I think these are the key ones. Of course, the children, the definition, 13 versus 18, right? But,
right, yeah. I just wanted you to sort of, in the same flow, could you add a bit about the differences in approach in cross-border data flows?
Yes. So in case of transfers, since GDPR has been most talked about, I'll just touch, I'll touch point there only. GDPR did say that, there were certain criteria for the organization to determine that whether they should be transferring the data or not, and how should they be transferring. For example, is there an adequacy decision given by EU? It basically means the country as a whole does have a law which is as robust or of a same security level as GDPR does. There could be some countries which are not doing so, but in case they're not going, then you're bounded by the code of conduct. You can have a contractual, clauses in your contract to ensure that they're following the same. But in India, what they've done is they said that it is the obligation. There's no country transfer regulations or rules for now, and they said that the data, it's the onus of the data fiduciary basically to ensure data processor, whether located in India or outside, has to make sure that they're they're complying, right? And all the more, while it is okay if you're transferring, let's say your data processor is in EU, you're transferring your data there, but what happens to countries where the laws are not robust? Let's say there's a small country, do not have a legislation as robust, then you're only, you're bound by only how data fiduciary will ensure that, the data processor is complying there. So I think.
Right, that's an interesting take, Neha. Thank you so much. Sriram, I'm really excited to hear from you because you represent a business, and most of everyone who spoke here actually are representing firms or independent lawyers. So I really want to hear from you. What are some of the practical challenges that you've mapped out and you're looking at in implementing and complying with the law or in preparation for it? So Sriram, over to you.
So implementation and preparation, I guess, are the key words here, because at this point the industry is not really taken by surprise by anything, because we've seen so many iterations of these rules come out, the act itself come out. And the version that just got passed is a lot more straightforward than some of the other drafts we've seen in the past. So there's nothing catching us by surprise. But the law's been out for 4 months, right? In terms of preparation and then moving to the implementation phase, there's still so much that we're waiting for clarity on, which, like others have pointed out on the panel, we expect the rules to clarify. And I think one of the key aspects there is also the timelines. On a macro level, obviously, we need to wait and understand which provision will come into force. When, as a company, how much time will we get to adapt once the rules are out and we need to implement those specific changes as well. And for a bigger company, if you're a significant data fiduciary, for example, based on the volume of processing, then there's an additional set of compliances. So you will expect or you will anticipate a slightly longer time frame for compliance. But also on the micro level, we will expect a little bit of clarity on various timelines internally within provisions of the law. It could be small things as well. For example, if I get a data deletion request, given that I now have an obligation to also make my third parties delete the data that I've transferred to them, how long do I have to action that request and make sure that it's completed from my end? So once we have clarity on those issues, obviously we can move forward faster. So I think the biggest hurdle in that sense would be the fact that we're expecting the sub-delegation of the legislation to take a more definitive structure, and so that we have a finished picture, right? So even today, when we're comparing the GDPR and the DPDPA, for example, I'm comparing a complete law to something that is still not fully fleshed out in that sense. And obviously, when the stakeholder discussions roll around, there we'll have a lot of things to say as an industry rep and say that, okay, this is how, in practice, when it comes to implementation, these are challenges that we anticipate. So that's a little bit in the gray area right now. But in terms of challenges for implementation, I would say that we would have to, I mean, going back to a lot of what Neha spoke about, is the differences between the GDPR and the DPDP Act. And why I'm saying that is because until the previous law was in effect, if you were GDPR compliant, you were broadly also compliant with the existing data framework. But now that is no longer the case. You could be fully GDPR compliant. You could be functionally doing all your compliances overseas and whatever, but there are some key changes, right? There's your consent manager concept, there's your verifiable age consent, all of which needs to be baked into legacy systems which have been operating in a certain way for so long. So while it's not a hurdle in the true sense, implementation will take a lot of technical coordination, spanning across business verticals and all of that. And for that, we need a high level of clarity from the rules so that tomorrow it doesn't come back to us saying that, okay, you did not look at this aspect or this got left out. So I think that's where we stand on the implementation journey.
Right. Thanks, Sriram. That's a very useful perspective and very optimistic about the rules as well. But Akshayy, do you want to add to that, especially in terms of what are the kind of practical
So
challenges?
adding to what Sriram discussed, so the DPDP Act is essentially a GDPR-style law, which has been drafted in a very simple language for ease of compliance. But what we have actually has happened is, we've in fact created a law which is much more complex in compliance than the GDPR. And a couple of examples, I'll deal with it. So like we had addressed, every company needs to determine a lawful purpose or a lawful basis for each different processing activity. And consent is only one of the lawful purposes. There are these other non-consent based lawful purposes which companies can rely on, which are our legitimate uses under the Indian law. Now, unfortunately, there are these two very important non-consent based lawful bases which are found under the GDPR, which is performance of a contract. So if anybody needs to process data for the purpose of performance of a contract, you don't need the consent of the individual. Second is legitimate interest. If the processing activity falls within the legitimate interest of a business and which does not override the interest and freedom of the individuals, then you can do that without seeking the consent of the individual. Now, unfortunately, those two non-consent bases have been left out under the Indian Act. And now the question arises, but how does it really impact? So I'll give you an example. Think of a situation, let's suppose there's an OTA platform. A user goes and wants to book a hotel or book a flight. So the OTA will provide a privacy notice and take the consent of the individual. And then it will transfer the data to the airline or to the hotel. Now the airline and the hotel will also process that personal data. They are also data fiduciaries under the law, separate data fiduciaries. But those entities don't have a direct interface with the user. So there is no opportunity to actually give a notice to the user and take the consent of the user if you don't have a direct interface with the end user. And in the EU as well as Singapore, Australia, across the world, typically performance of a contract was the lawful basis which was relied upon by these companies who did not have a direct interface with the user. Now, under our legitimate uses, that's been left out. So that's going to be extremely challenging for companies to comply with. And I think the second challenge, timelines I won't discuss further because, under the GDPR, they gave companies a period of about 2 years to comply. But in India, the minister has on numerous occasions stated they're looking at 6 to 8 months for compliance. So that's going to be an extremely challenging exercise for companies because a data mapping exercise just for a company to find out what data it collects takes a significant period of time. So the clock is ticking, and I think the timeline is something I think all businesses would be worried about.
Right, I think the clock is ticking is a very timely thing for me because but we're just going to take a couple of minutes extra and not hold you back from lunch. But I want to bring Dr. Karnika Seth back here. And I want to ask, what are the first steps that a company should really take in terms of getting prepared for this law? And I also want to hear from Sriram on this. But Karnika, please go ahead.
So Now, essentially, when we deal with companies and we advise them on DPDP compliance today, we understand the timelines are not clear yet. There is a lot that can be done at this point. For example, we understand what data they're collecting and how they're storing that data, what use they are making of the same, and if they have engaged vendors, other servers in India, or the processing happens outside India, and how the transfer takes place. First of all, to which countries? Because there's also a power with the central government to restrict the data flow to certain countries. So looking at that, then also, whether this data which is going out, is it anonymized? Is it for use of research, marketing, or archival purposes? Or is it something for performance of contract, for example? Then also we look at, how long this will go and be stored. And if it's with a processor, then what are the back-to-back arrangements between data fiduciary and the processors? Are they of the same reasonable security standards being maintained as we have promised the user? That is the principle, data principle. So a lot of these issues we look at. The most importantly, we look at the data. What is the data? Then who are the entities who dealing with the data? What use is being made of it? What are the retention timelines? And in what format it is stored? So all this is important because pseudonymization is also permissible. It's something which is encouraged. Encryption is encouraged in terms of security. So even though we don't know as on date what security technical standards will be there, but these are some benchmarks which are already accepted even under the GDPR. So if you look at the standard contractual clauses, or you look at the way GDPR is prepared, these are some technological measures which are strongly advocated, and that's strongly encouraged. So that's something which we as a norm understand that this will be a base at least. So apart from this, we look at how many countries are going to be involved. If it's a lot of vendors, a lot of countries, then if it's GDPR, are we dealing also with European citizen data? That means we are going to comply not only with DPDP but also GDPR. We also look at aspects where, for instance, certain rights like right to nominate has been given under DPDP, is not there under GDPR. So we look at legally vetting the policies, the privacy policy, the terms of use, and the notice requirement, the way the data is flowing. We essentially prepare a hierarchical chart or the Excel sheet sort of a thing of how this data is going from one jurisdiction to the other, and are we doing everything which is permissible as per the norms laid down by the DPDP framework. So it's not just technical organizational measures, but also the templates, the legal documentation, which is going to be overhauled as first steps.
Okay, thank you. I think that's quite a comprehensive thing. I understand we're really short on time, but I really want to hear from Sriram and also go to Dr. Pavan Duggal. Sriram, 30 seconds, quick summary. Sure. I'm sorry to really cut you short on this.
At the risk of repetition, a lot of it's been covered because I think the primary step for compliance is going to be a painfully expansive data mapping exercise. You need to, because there is no compliance under the law that you can do without mapping out every single data point that you have, where it's going, where it's stored, what's your data retention policy, who has access to what, and all these new compliance that are coming in, like verifiable age consent, am I collecting the legal guardian's information as well, if there's a nominee's information, so many stakeholders across the company. By the end of the process, you'll discover that your cup is just overflowing with data points you may not have entirely accounted for during the time. So that is the first step. And once you have that, then you can start with your structured definition of processes and systems and how you document that legally within your contracts, your privacy policy, your notice, and all of that. So your first step is going to have to be a very, very thorough data mapping exercise.
All right. Thank you. I think that mapping and inventory process is going to be quite an ordeal. Dr. Pavan Duggal, I want to come back to you and give you the last word, in fact. We've discussed about how this law has, required a lot of compliances and the different interactions with the other laws. How do you think this will sort of impact how companies assess cybersecurity with the other regulations like the CERTIN or the TRAI's Digital Consent Acquisition Framework, the RBI's data localization mandate? Any comments on the interaction with the larger legal landscape and the last word on it? Also, 30 seconds, Dr. Duggal, sorry.
Clearly, there are a lot of challenges. There will have to be intermingling. The intermesh between different legal networks will have to be seen. But I already begin to start seeing teething problems in this direction. So much that there is a lot of euphoria that the DPDP Act does not come up with any data crimes. It's the criminal liability both under the IT Directions 2022 and under Rule 7 of the IT Rules 2021, which should keep a large number of corporate boards and the CXO level people more awake and be bothered about the fact that apart from this 250 crore figure that's going to hit their potential companies, it's also going to be criminal liability. So I think due diligence, caution, care, and compliance will have to be only guiding mantras. Well, good, bad, or worse, this is the law of the land. Till such time this law does not get set aside or is not amended, it's the bounden duty of every stakeholder to ensure compliance with this law for the selfish purposes that you protect your legal interests. Otherwise, the 250 crore rupees per contravention fine going to the government of India is going to pinch large number of companies apart from even extinguishing their existing business practices. And also the criminal liability is something that a lot of the corporate stakeholders will have to be aware of. So let's go ahead and comply with this law. Let's hope there's more clarity coming in the rules, but don't wait for the rules. We are Indians, we love cricket, and we love to hit 6 sixes on the last over of a T20 match. Please remember the DPDP is not going to give you that particular frequency or that leverage. You will have to make preparation right now before you come in for the final over. Why? Because the rules come in and they will get implemented almost instantaneously. There might be a small interregnum period of some kind of preparation, but it's better to be prepared now rather than facing a barrage of complaints against you for your non-compliance with provisions of the DPDP Act.
Right.
Thanks.
Thank you so much, Pavan, for that. I think I'm not going to try and summarize any of this discussion, and we're already out of time. But I want to thank each of the panelists for their brief but exceptionally informative inputs. Thank you to the audience for paying attention.